Hi, my name is Kim Cullen, and I'm a personal injury attorney in Winter Park, Florida. We talk to people virtually every day who've been involved in accidents, from car accidents to motorcycle accidents to truck accidents to slip and falls and more. One of the first things that we try to do as attorneys is to make our clients feel comfortable with us and comfortable enough to tell us everything. And so once we've had a chance to sit down with our clients and explain how the attorney-client privilege works and make them feel comfortable with us, sometimes our clients reveal to us that at the time of their accident they had either been drinking alcohol or taking some kind of illegal or legal drugs. And most of those people are justifiably worried that they may not be able to have their medical bills paid just because they were drinking or taking drugs at the time of their accident. There's no question that drinking or taking drugs can potentially create a big problem in a personal injury case. And the reason for that is a Florida statute. It's section 768.36, which is commonly called the alcohol defense. The alcohol defense essentially says that a plaintiff in a civil case cannot recover any money from a defendant if at the time of the accident the plaintiff was impaired by alcohol or drugs, or if the plaintiff had a 0.08 blood or breath alcohol level, and that as a result of the plaintiff being intoxicated with drugs or alcohol, the plaintiff was more than 50% responsible for causing the accident. The good news is that this defense is usually pretty hard to prove. The question of whether the plaintiff is impaired or not is often a very heavily disputed fact. And also, many times there's no blood alcohol level reading for the defense to take advantage of. And even if there is, a lot of times we're able to keep that evidence out because of chain of custody issues in the hospital. And secondly, there's always a dispute about whether the plaintiff is 50% or more responsible for his or her injuries. You know, that's usually a bone of contention in most personal injury cases anyway. However, if our client has been under the influence of drugs or alcohol, many times we have to take a little less strong position than we typically would, and a lot of times we have to compromise the value of our client's cases just because of that fact. So anyone that's pursuing a case that's been drinking or under the influence of any kind of drug needs to understand it's very, very difficult, if not impossible, to recover full value on those cases. That said, we're usually able to make some kind of recovery for our clients and at least help them with their medical expenses or lost wages or other damages that they've received in an accident. So if you've been involved in an accident that where there's a question of the consumption of alcohol or drugs and how that may have contributed to the accident, you probably should seek the assistance of an attorney. An attorney is going to be able to best represent you and give you the best advice on what you should do. So if you have any questions regarding an accident where drugs or alcohol might have been involved, please give us a call. We'd love to answer your questions. Our phone number is 407-254-4901. You can text us at 407-644-4444, or you can even reach out to us on the Facebook Messenger app.